some of the other misinformation about the case that is widespread, and you gentlemen are as aware of it as I am. Now they had some people in the Milwaukee Journal, I think I read it, which is the paper that I used to deliver for a few years when I was a preteen, in the Milwaukee Sentinel, which are now one paper, that they talked to some professors at the two law schools in the state and said it was odd, I think was the word, that I didn't rule on the motion to dismiss. I haven't even had a chance to read the motion to dismiss. I just got it yesterday, and I really think before I rule on a motion, I should let the state respond. So why anyone would think that it's odd for the judge to sit on a motion to dismiss, I have no idea. I think that, and the recommended course, I think, for judges, at least that was what I was educated to believe, was that motions to dismiss should be kept under advisement unless they're crystal clear and have had a chance for both parties to respond, which we didn't have in the heat of the discussion on the day the original oral motion was made. I never heard your side of it in terms of argument. So I'm somewhat astounded, but of course it gets out into the general public. And as I spoke about it on the first day of trial, the result of the trial should be open to public scrutiny, and people should have confidence in the outcome of the trial. I think we can all agree on that, and it's just a shame that irresponsible statements are being made. And as long as I'm talking about it, I guess I'm going to talk about that too. The business about people not being identified as victims. How would you like to be put on trial for a crime? And the judge introduced the case to the jury by introducing you as the defendant and the person who is accusing you as the victim. And then throughout the trial, have all the references to the complaining witness as being the victim. Is it so difficult to just use the term complaining witness instead of prejudging what the jury is here to determine as to whether there's a victim and whether there was a crime committed? So I don't know what I'll leave that comment at that. And then finally, I'm now reading about how bizarre and unusual it was to have the defendant pick the numbers out of the tumbler yesterday. And I would admit that I don't know that there's a large number of courts that do that, maybe not any. I do it because of an incident that I had in a case I tried in Racine. Oh, I'm going to say I estimated 20 years ago it could have been less than that, it could have been more. But it was a big case. I think it was a murder case, but I'm not sure. And there was a black defendant, and there were 13 jurors, one of whom was black. And when the government official drew the name out of the tumbler, it was a black, the only black. There was nothing wrong with it. It was all okay. But what do they talk about? Optics nowadays? Is that the word for things? That was a bad optic, I thought. I think people feel better when they have control. So ever since that case, I have, ever since that case, I've had an almost universal policy of having the defendant do the picks. It had nothing to do with anybody's race or anything like that. And I never had a complaint about it before. In fact, I haven't had a complaint about it here. But some people seem to be dissatisfied with that, and people who want to undermine the result of the trial. So that's today's statement on that subject.
All of that, Your Honor, is why I do my best to avoid reading anything anybody's writing out there about this case, because we know what happens in here,
right.
And they don't.
Well, and I don't always have that luxury, though, because I've got a...
Sure.
But anyway. And some of the things that have been said, too, I guess I'll comment on that, too. These are 5 very reputable, competent attorneys that I've practiced with for years, and I think it's shameful, some of the things that are being done to these people. And when I talked about problems with the media when this trial started, we're there in part, not fully, but in part, because of grossly irresponsible handling of what comes out of this trial. I will tell you this, I'm going to think long and hard about live television of a trial again next time. I don't know. I've always been a firm believer in it because I think the people should be able to see what's going on, but when I see what's being done, it's really quite frightening. Frightening, that's the right word for it. But back to the subject at hand. And I've discussed my disdain for the rule. I'm not going to box you guys into accepting what I think is the better way, and I sense from the statements that have been made that I think that in some respects you may even agree with me that it would be better if the jury could. We're going to now have the jury will come down here to the courtroom, and everybody will be shooed out of here as they should be. And I'm not even sure. We're going to have to review the procedure that's been outlined. But they get to watch it once. Is that what the rule is?
I think they should be allowed to view what they want to view as often as they want to view it.
Subject to my other objection, I don't have a problem with them viewing it multiple times. At a certain point, I don't think that's,
I don't think that's enough.
3 or 4 times, I don't have a problem to sit here and just keep playing it. I don't think that's the right way either. Then it's giving more emphasis to one piece of evidence.
Well, but sometimes there's one piece of evidence which is absolutely critical. And I talked about the Tsarnaev case. I talked about the attempted murder case that I had in here. And I don't know how we're going to police this anyway. And the other thing is when it is being policed and someone's watching them talk about it, well, can they freely talk? Which is what we want. We want freedom of expression between the jurors. And so as they watch these videos, and to me, if they want to watch it 100 times, that's them. If it were a bench trial, and I've said this before, if this were a bench trial, and I put in my decision that I thought that Exhibit 486 was critically important, but I didn't want to overemphasize concentrating on it, so I left with questions in my mind about it and decided I better not look at it anymore. I should get reversed. That's an outrageous thing. But that's what we're forcing the jury to do because of the disrespect that the courts have had in this country for the juries. These are intelligent people. They get treated like there was a time when the educated people in the town were the physician and the lawyer and maybe the school teacher and the preacher, and the rest of the people were farmers. So obviously they weren't as smart as those educated people, right? Wrong. That's never been the belief of the founders of our country. It's never been true. And I think these people are as competent as the educated people, and many of them are educated, to make these decisions. And that's where the founders of our country put the power, not with us. So I think it's insulting to the jury to tell them that they have to have these restrictions on their viewing, but we're going to sit down with the books. We're going to find out what the exact procedure is, and we'll await what they want to do. But for now, I will answer: do we view the videos in private or in the courtroom? And the answer will be in the courtroom. Do you need to know the exact exhibit number or video or photo? Well, there's 2 options. One is you can have all of them. Anyone gasping? You can have all of them, whatever you want. You can pick and choose. And You can,
I think we're-
or you can describe generally what you want.
Yeah, I think the exact exhibit number would be helpful, but if they can give us just a title or a description, we can also figure it out.
I agree.
All right, so what I'm going to write, you've got copies, so what I'm going to write on here is in courtroom, I better write pen. General description. General description of what you would like. Is that all right?
Yes.
The only thing I would ask about with regard to your answer, Your Honor,
Yes, sir.
I'm not sure I heard you correctly about if we bring the jury back, you mentioned something about kicking everyone else out of the courtroom.
Okay.
And I don't know what you're planning to do, but if you are planning on doing that, it might be helpful to tell the jury that so they understand that they would be viewing it without the public around. I don't know what you're
That's a
planning
good
on.
point. That's a good point. Except that I don't know exactly who are going to be the kickies. Certainly, all the media and the officers, other than the media and the officers, and the question is whether the lawyers and the defendant. I don't know what the answer is. We'll have to check that. And I don't know if I'm supposed to be in here. I got the impression, and it's been a long time since I've read one of these cases, I got the impression it was actually supposed to be the bailiff, but I'm not even sure about that. So we'll have to look at that. So I guess I understand that was a good suggestion that you've made, but I'm afraid I don't know enough of an answer right now. So I'm going to send this up now.
Thank you.
All right, would you make a copy in the upstairs?
And then, Your Honor, can we be excused to go do some research on what you're talking about?
Please do.
Okay.
Please do.